Well, hi there. Warm welcome. You're watching the Blueprint Explosive Exclusive with me, Meghna Deka. Well, viewers, it's happy to say it's a happy moment, a joyous moment, because today, finally, secular laws are going to reign supreme in Bharat. That's right. In a landmark verdict, the Supreme Court today has upheld the right of maintenance for all women irrespective of their religion under Section 125 of the CrPC. While this is a huge step towards gender equality, it has also turned into a political slugfest. In fact, the BJP has raked up the ghost of Shah Bano and an act which was passed by the Rajiv Gandhi government in 1986 to target the Congress party. While we'll get you the politics over all of that and the politics over Shah Bano and why today many are saying that after 38 years there is justice, a glimmer of justice for others just like Shah Bano. We'll get you the politics behind that, but first let's explain what exactly it is that the Apex Court today has ruled. In fact, the big judgment has come as a bench of Justice B.V. Nagaratna and Justice Augustine George Massey dismissed a Muslim man's petition which challenged a direction which was given to him to pay maintenance to his divorced wife under CrPC. In fact, the court had maintained that secular laws prevail over the personal laws and has said that provisions of the Muslim Women Act of 1986 do not override the secular law of CrPC. 125 section, that is the specific section. But let's also break down the key takeaways of the Supreme Court judgment and tell you what exactly it is that the justices have said. The first judgment which came in, and this is the operative parts that we are getting you from this judgment, it says that the 1986 Act confers the benefit of maintenance for divorced Muslim women. Not just Hindu women or any other religion, it is for Muslim women, for women irrespective of what their religion may be. The Supreme Court also said that Muslim women can seek maintenance under the secular provision of Section 125 of the CrPC and not just limited to the Act of 1986 which was passed under Rajiv Gandhi. In fact, it says that the cancellation of alimony only if the wife ends up invoking both the acts, which is that of CrPC as well as the 1986 Muslim Women Act. It also has said that both the 1986 Act as well as the CrPC are parallelly existing in their own domains as well as jurisdiction, that neither of them is bad in law, both of them can correspondingly and parallelly exist within India's jurisprudence, and that the right of a woman to seek recourse through CrPC despite the existence of the 1986 Act continues. What does this mean? It means that a Muslim woman, when she gets divorced, can take recourse of either one of the two acts, be it the Muslim Women Act of 1986, where she is going to be allowed to give and get alimony during the iddat period. You also have the recourse which is available to a Muslim woman to invoke the CrPC, Section 125, and get alimony as per the secular laws of the land as well. In fact, the right of a woman to seek recourse exists in both CrPC as well as the 1986 Act. In fact, the Supreme Court has categorically stated that the 1986 law does not bar any woman from seeking alimony under the secular laws as well. This is what the observations which have been coming in. And I'll get you there on the big screen. It says that the Muslim Women Act of 1986 does not bar any such remedy that she can now invoke. It also has observed that it is the choice of the person who applies for the alimony as to which one of the two she wants to invoke. There is no provision which says that Section 125 is not maintainable for a Muslim woman, and the Muslim Women Act of 1986 does not override the secular law of Section 125 of the CrPC. So while the opposition leaders have hailed the verdict, the BJP has pointed fingers towards Rajiv Gandhi's legacy. Now, why is that? This is the Shah Bano angle which has been injected. Remember, the Muslim Women Protection of Rights on Divorce Act of 1986. It was passed by the Rajiv Gandhi government to try and circumvent the then Supreme Court verdict of Shah Bano. This has been largely seen as an appeasement tactic to try and pacify the minority community by Rajiv Gandhi. Congress, on the other hand, meanwhile, has countered the charges, saying that politicization of the issue is completely shameful and has said that BJP should also think about Bilkis Bano. Listen in to this war of words.
हाल में संपन्न चुनावों में और उसके बाद शपथ ग्रहण में संविधान लेकर जो लोग आए थे, सर्वोच्च न्यायालय के डिसीजन ने भारत की संविधान पे आए सबसे बड़े संकटों में से एक का उत्तर दिया है। 1985 शाह बानो केस आता है, सर्वोच्च न्यायालय का निर्णय एक गरीब मुस्लिम महिला को, शायद मुझे ध्यान नहीं है, 120 रुपए या कुछ ऐसे के आसपास का मेंटेनेंस देना था, और उस समय यह लगता है कि यह शरिया के विरुद्ध है, तो तत्कालीन कांग्रेस सरकार जो स्वर्गीय राजीव गांधी जी के नेतृत्व में चल रही थी, उसने सर्वोच्च न्यायालय के निर्णय को रौंद कर संविधान से ऊपर शरिया को कर दिया था। मैं चुनौती से कहता हूं, दुनिया में एक सेकुलर देश बताइए जहां सुप्रीम कोर्ट के जजमेंट से ऊपर शरिया होता हो। संविधान खतरे में था। यह हमें फिर याद दिलाता है कि संविधान को कितना बड़ा खतरा, जब जब ये सत्ता में आए हैं, अनेक अनेक प्रकार से संविधान को खतरे में डाला है।
देखिए, मेरी निजी राय पूछेंगे या महिला कांग्रेस के राष्ट्रीय अध्यक्ष के तौर पर सुप्रीम कोर्ट के इस फैसले का मैं स्वागत करती हूं, क्योंकि सुप्रीम कोर्ट का ये फैसला ने महिला को महिला के तौर पर देखा है। अभी गुजरात के जो बीते चुनाव है, उसी में आपने बिल्किस बानो के 11 सामूहिक बलात्कारियों को छोड़ा संस्कारी बताया। ये तो अभी की बात है। हाँ, अपने गिरेबान में झांकिए और चुल्लू भर पानी में डूब मरिएगा। अगली बार जब इस तरह के फैसलों पर भी आप राजनीति करें।
Well, in fact, let me go across to our panelists today. Joining us today on the show, we have Anuja Kapoor, spokesperson with BJP. There's Shalini Ali, who's joining us, a national convener of MRM. Lubna Kamal is joining us, a social activist. Shalini Ali, I'm going to be coming to you first because it's important for us to understand the significance of this. Because even though today we all understand that the Supreme Court has categorically said that it is the prerogative of the Muslim woman to decide whether she wants to seek alimony under the secular laws of CrPC, or else she decides to go with the Muslim Personal Law Board, that it is her decision. However, none of the two laws are today being called bad in law. They are both concurrently present in India's jurisprudence. If you can explain the significance of it all today.
See, firstly, I would like to acknowledge and I would also like to applaud the Apex Court for passing out a judgment in favor of women, especially Muslim women, because we have seen in the past years, it still gives me shivers when I read about the Shah Bano case, where a 65-year-old woman has to go into court to fight for maintenance, where she has to fight for her own existence. She has to ask for money. मतलब भीख मांगने वाली स्थिति जो थी उस महिला की, उसके लिए she had to go into court. And when it was then awarded to her, the All India Muslim Personal Law Board, as usual, the bad cops for the Muslims. I don't go any beyond in saying this, but they are actually the bad cops. They feel that they own all and each and every Muslim citizen living in India. And then they start off with this new law that they say that no, they cannot rule over us. The country does not have any hold upon the Muslims. We are the All India Muslim Personal Law Board and we are going to challenge the court for the CrPC 125. Rajiv Gandhi ji comes in and he tries to think of a new way where his government passes the Act of 1986 for Muslim women, the divorce laws for Muslim women. The main difference between two is that the first and foremost condition for the Rajiv Gandhi, for the 1986 law that was passed on, was that she will be given maintenance for the 3 months of iddat. That is somewhere around about approximately 3 months, right, plus or minus. Now in that 3 months, mind you, I'm going to correct myself and other people also who are going to be watching this, that it was further on also amended where it will go into a period more than 3 months. Where was the awareness that, okay, the woman can get maintenance for more than 3 months? Where was the awareness? There was no awareness for that. Where is the awareness where the women who are the victims of triple talaq, or even today, after the triple talaq rule has come in, the law has come in, they still lead lives of being near to beggars, and no maintenance is given to them. So first and foremost, the awareness amongst the Muslim ladies was needed, which was again reaffirmed today, whereas they know that after being divorced, they can gain maintenance for their livelihood, they can gain maintenance for themselves and their children till the time they remarry. The choice is there.
Absolutely.
They can either
the
go
choice
by
is there. They can apply under the secular law as well as the Muslim personal law. And it's important for us to point that out, that the choice is again given and vested by the Supreme Court in the Muslim women themselves. Lubna Kamal, then why is a certain section still trying to snatch away one of the options available to Muslim women?
There's another point.
There will be always appeasement by the politicians. They will always, part of the game. And I would request all the Muslims, the women especially, to rise beyond that. Why?
But Lubna Kamal, this is not about politics. In fact, I have not gone to Anuja Kapoor myself right now because I feel this is not a political story. This is about women's rights and this is the Supreme Court. So let's continue with that.
See, it's a great move by the Indian judiciary, and all Muslims, all Indians should welcome this. No doubt about that. What I was coming to next was that Islam is flexible. Its boundaries are flexible, and there is a term called usuli ijtihad, which by which we can interpret whatever the laws were framed 1400 years back. They can be reframed in the light of 21st century. So that is something what most Muslim clerics, they do not want the women to know, because all the laws, all the whatever the rules are there, they are to subjugate the women and especially the Muslim women. They were framed by the clerics. So now it is the time for Muslim women to wake up and rise beyond all of this and get what they deserve.
Yes, it is time for the Muslim women to be aware of their rights. After all, it is the Supreme Court, not the first time. This is the second time that the Supreme Court has made it very clear in its judgment that women have the right, despite the existence of the Muslim Women Act of Rajiv Gandhi. Anuja Kapoor, it's interesting because many people are today saying, had Shah Bano been there today, there would have been at least a glimmer of justice for many other Shah Banos today. Do you think it is some kind of a vindication for the kind of fight that that woman had to put up and the despair that she was plunged into?
Yes, Shri Ram, and good evening. Meghna, I would first of all applaud to all the women, and I congratulate to all of us that the woman has risen and the woman has become a phoenix. She has risen from the ashes. And I congratulate you, Lubna. So you have spoken so well. I feel so good about it. The woman panelist who is the Muslim who has spoken that all the women should rise up now. And this is where the era of Rajiv Gandhi, which was the era of communalism, when they were trying to separate Hindu and Muslim on that factor. Now the secularism has come up. When we talk about Bharat, Bharat is the beauty of secularism. And this is where Modi ji has talked about Sabka Saath and Sabka Vikas. And I again congratulate you all on the triple talaq which has been abolished, which has allowed a breath. Imagine those women who had to go, like my other panelist, she has said that bheek maangne jaisi position thi Shah Bano ki. Aur wo wahan gayi, she went to the court because she could not find any other place to talk about it. The maintenance is her right, not a charity. We are talking about and celebrating the legal right, the constitutional right, and the fundamental right. And this is where the woman should see herself. The woman empowerment should not be on papers. It should be in the legal, constitutional, and in the fundamental itself, which is upheld. And I feel that Modi government is a pro-woman when we talk about Gyan, Garib, youth, Antyodaya, and then we talk about Nari Shakti. This is where it belongs. Because what is important is looking at the woman not from as a chisel, as an object, But seeing the woman as a partner, seeing the woman as the 50%
Right.
of Bharat. This
Lubna
is very
Kamal,
important.
very important points that you've raised. Let me take that across to Lubna because you've addressed it to her. Lubna, the fact that we've seen that there is a law against triple talaq, there are several other tweaks which have been made. In Jammu and Kashmir, you have the domicile rules where the children of daughters of Kashmiris will not be discriminated against because they are the daughters and not the sons, progenities. Similarly, there are several other tweaks which have been made. For example, when a woman today wants to go to Hajj, she does not need a man to accompany her. Would you say that steps are being taken legally to ensure that women's rights are not being trampled upon, the very appeasement that you had spoken about earlier?
Yeah, this is actually great, and I would congratulate the government for taking up, so many things and being like victorious, emerging victorious as well at the same time. But there are few more things which I would request to Anuja, because she is the spokesperson for the party, that there are women who definitely, there are Muslim women, there are Hindu women who definitely need maintenance, but this should not serve as a means to extort money, because there are women who are just lazy and they're just doing it for vested interest, for, extortion. I get these kind of,
Okay, which is why we, I believe, have the courts to decide on a case-by-case basis. Shalini Ali, one quick last word I would like from you. Do you think now we are paving the way for a nationally implemented uniform civil code?
Absolutely right. As a matter of fact, today earlier on in our interview, I did say the same thing, that this is the reason why we need to implement UCC ASAP. As a matter of fact, when we had gone to the Law Commission, I had taken a contingent of Muslim ladies who had gone with me, and we brought about a lot of points which we want it to be inculcated in the UCC. For example, Islam is the only religion which has a nikah-nama, which is actually a contract. It's a contract of marriage. And now the contract does not have the terms and conditions as they are supposed to be put down on. All these points are supposed to be stated in the nikah-nama, in the contract, and then they are supposed to be read and then signed, and that contract is going to remain with you till the end of your marriage, if that's so, otherwise till the end of your lives together as husband and wife. So we as Muslim women have been wanting all these issues to be addressed, because there is a lot of appeasement. There is a lot of awareness also. We have young girls who are now studying, who are educating themselves, who are reading the Quran in the language that they do understand. They are not going by the Maulanas and the Maulvis and the clerks that are trying to, put across a religion which is not the way it has been stated at the Holy Quran. So that is one of the main reasons that we see this as a movement
and with rights
forward for
comes
UCC,
the emboldening of women, and rights and education, which will ensure that we have true gender parity. Well, thank you so much, all our panelists, lady panelists today. Good to have you all on the show. Anuja Kapoor, Shalini Ali, as well as Lubna Kamal for joining us. Without a short break, we're returning in 2 minutes. But of course, this is one of our top focus stories here on Times Now.